The topic of my talk is the International Criminal Court and state sovereignty, and more precisely, the way I do address this relationship in my own research work. So let's start from the major question that my research addresses. What is the regime of state sovereignty being unfolded by the court? And more precisely, to what extent does this regime amount to a postmodern or post-Westphalian form of organizing political space? Well, few attempts have already been made in order to grasp potential answers, both in the discipline of international relations, from which I come, and in international law. However, the existing body of literature carries some difficulties. First of all, difficulties in theorizing state sovereignty. Secondly, difficulties in theorizing change, and especially theorizing it from a perspective that does take change seriously. What does it mean? It means a perspective which does not regard change as impossible, but at the same time does not take it for granted. And finally, difficulties in theorizing change in state sovereignty and integrating the more normative aspect of the question into a systematic empirical diagnostic analysis. So, what I'm trying to do in my current research work is to embark on all these challenges, at least to some degree. The theoretical framework where my analysis is located is the English School Theory of International Relations, whose nested hierarchy of international institutions helps me analyze the ICC, the International Criminal Court, as an empirical reference of change in state sovereignty. According to this hierarchy, state sovereignty is the master primary institution, where primary means constitutive, is the master primary institution of the modern or Westphalian system of states. And non-intervention and international law derive from state sovereignty as derivative primary institutions. In turn, the ICC derives as secondary institution, where secondary means produced by state. It derives as secondary institution from international law. So, my research currently pursues three main objectives. The first two are operate at empirical diagnostic level, while the third objective is actually about rejoining the empirical findings with a sort of normative analysis, where normative means an analysis about norms and the norms of international society. So, the first of these objectives is to identify the provisions of the statute about the conditions under which the ICC can break into state sovereignty, first, and secondly, to identify the regime of sovereignty being portended by those provisions. Well, jurisdictional provisions in general are relevant to this purpose. insofar as they condition to some degree the division of labor between the court and national authorities. However, I think that the provisions concerning admissibility are even more crucial. The reason is the following. The admissibility test arises only once it is determined that the court does have jurisdiction, and admissibility is about determining whether the court, rather than the state, which might have concurrent jurisdiction, whether the court, rather than them, has to exercise jurisdiction. So the so-called admissibility issues are mainly expounded by Article 17 of the statute, which encompasses two factors, complementarity and gravity. In very broad terms, complementarity means that a case is admissible before the court only if states which might have jurisdiction are unable or unwilling to genuinely pursue that case. But complementarity also says that the court is the ultimate judge as to whether those states have exercised jurisdiction and as to whether they have done it in a proper way. Gravity says that for a case to justify the intervention of the court, this case must be of sufficient gravity. However, what I propose is to consider Article 17 in conjunction with Article 53 of the statute, which is about the power of the prosecutor to initiate an investigation or prosecution. The reason is the following. According to Article 53, the admissibility criteria which Article 17 leaves substantively broad are to be given effect, are to be determined by the prosecutor within his or her initiation power. So as a result, the mechanism emerging from Article 17 and Article 53 together gives room for the following. A prosecutor shaping the concepts and developing prosecutorial discretion beyond strictly legal thresholds. Secondly, it gives room for a selection of cases and situations to be brought before the court. And ultimately, it gives room for prosecutorial policy, which wouldn't exist without prosecutorial discretion. So this is the first objective. The second objective operates still at the empirical diagnostic level, but it moves from the statute of the ICC to the practice or the prosecutorial policy of the court. So what this objective is about is determining how the provisions of the statute, and especially Article 17 and Article 53, translate into the court prosecutorial policy. Right now, I'm in the process of analyzing all the 22 cases corresponding to 9 situations which have been brought before the court, and I'm organizing them according to the mechanism that has triggered the court jurisdiction, namely state self-referral United Nations Security Council referral, and prosecutors' proprio motu power. The next step is determining emerging patterns in the emerging prosecutorial policy of the court as to finally determine under what conditions state sovereignty is actually superseded by the court. This is the second objective. The third objective is about determining how and to what extent the regime of sovereignty unfolded by the ICC does differ from the modern or Westphalian configuration of sovereignty. So at this stage, a clarification about what Westphalian or modern sovereignty entails is needed. Well, Westphalian sovereignty conventionally refers to a political organization based on the exclusion of external actors from authority structures within a given territory. However, the history of Westphalia tells us that the principles of autonomy and non-intervention have also been frequently compromised, both by means of intervention imposed by more powerful actors and states, and also by means of voluntary agreements. So the history of Westphalia must also be incorporated in any definition of what Westphalian sovereignty does entail. Well, for now, the focus on admissibility seems to preclude any clear-cut conclusion, and especially seems to preclude any conclusion of the kind of purporting either the overcoming or the restatement of state sovereignty. And indeed, this ambivalence is already well encapsulated by complementarity. And by the way, complementarity is articulated in the letter of the statute, insofar as complementarity, on the one hand, stipulates the primacy of the state as primary locus for the exercise of criminal jurisdiction, but then, on the other hand, it actually thrusts in the supranational authority of the court.